Is it visible?
Yes, ma'am.
Okay. So welcome to the session. First of all, what is a trademark and why does it matter? So as you can see on the slide, trademark is basically a mark or a symbol is capable of graphically represented and distinguishing the goods and services of one person from those of others. Now, if you go to USPTO or WIPO or EU, you will see similar definition of trademarks. Now, why trademark is important? As we are turning into a globalized economy, it's very crucial, quintessential to protect our brand, to protect its goodwill, to protect its reputation. And this is where trademark under IP domain comes into play. It matters because it prevents your competitors from using your identity or deception from riding on your goodwill. Second is to establish a market identity, a distinct market identity, so that it builds consumer trust. For instance, if you have heard of Tiffany & Co., if you see just the color, you will appreciate that it's this particular brand. Or if you see red for Ferrari. So these are their market identity. They are not trademark per se, but they are part of their trade dress or they are part of their color scheme so that you can identify a particular brand without even saying or grasping a word. Now, it's a huge business asset. Once you have created a market identity, once you have your brand, it is crucial to diversify that brand also. And for diversification, that's where trademark comes into play, in assignment, in licensing, so that your brand can be protected whilst your brand continues to grow. We all have heard that after LPG 1990s, several brands came into India, McDonald's, Domino's, there was an influx, but they are not Indian brands. So how they are functioning and protecting their identity in our domestic market? That is because of their licensing and assignment rules, because we have specific laws, trademark laws in place to protect their identity. For instance, Walmart came into India through Flipkart. Aditya Birla Group itself has certain huge brands that you buy every day licensed under their goodwill, because it is already a well-established brand in our domestic market. Last but not the least is legal remedy. Now, legal remedy is a very important part of trademark. It's post-registration. It can be without registration also. We'll get into the detail, but it is a very quintessential part of post-registration part. Now, legal remedy, we have multiple legal remedies. I would like to just go over it because it's part of your enforcement portion, and I think other person will be able to tell you more about it. I'll just throw a cursory blanket over legal remedies under trademark. Even though registration is important, there exists a remedy for non-registered brands also, because a goodwill is created. It's an intangible, non-tangible asset that needs to be protected. For that, we have passing off. Under Trademarks Act 1999, it is under section 27(2). So passing off is, the essence of passing off lies in misrepresentation. Courts have consistently held that passing off protects the goodwill and reputation of a business against deceptive practices by competitors. The most fundamental difference between infringement, which is a legal remedy, is a statutory remedy, I would say, and passing off is the source of rights. Trademark infringement arises from statutory rights under Section 28 and 29 of the Trademarks Act, while passing off arises from common law, rights preserved under Section 27(2). I'm sorry. Now, there is a very landmark case that came in this year, which is Tukral Mechanical Works versus PM Diesel, in which the court reiterated that while the registration continued to subsist, the superior goodwill and prior user rights of PM Diesels is entitled to protection against passing off. The court further relied on Section 34 of Trademarks Act, which protects the rights of a prior user against a registered proprietor, holding that registration cannot interfere with the use of a trademark by a person who has been continuously using it from a date prior to either the use or registration by the proprietor. As you can see, if you have established a brand, you have protection before registration also and after registration also. It just, the extent of your rights expands exponentially after you get your registration, and that's why trademark and trademark registration is important. Now moving to second slide. Now we'll come to a very basic overview of genesis of trademark law. So first there was Paris Convention. However, Paris Convention did not have a separate trademark order per se, but it applies to industrial property in the widest sense, including patents, trademark, industrial design, utility model, trade names, and geographical indications, as well as some portion of unfair competition. Then came one of the important agreements, which is Madrid Agreement. It was concerning the international registration of trademarks, and its protocol gives the system for the international registration. It helps us to protect our mark in several countries by obtaining single international registration. The key is in the designated contracting parties, not everywhere, only in designated contracting parties. Now, during my master's, I came to learn about BIPRI, or as you can see, United International Bureau for the Protection of Intellectual Property, which was further transformed into WIPO, which we still use as an international benchmark for IP law. Then came Madrid Protocol, then Nice Agreement. Now, Nice Agreement is very, very important if we are filing for a trademark, even if we are reading about trademark. It provides for an international system of classification of goods and services, which is widely used around the world. A trademark application refers to a specific sign in connection with specific goods and services. Now, the member indicates a class in goods services from NCL number. So it becomes very easy in docketing and recognition of trademark. It's a fun fact that we got a new trademark Nice classification edition, which is enforced from 1st January 2026. There were some minor agreements, you can look into it. But yes, that's a good trivia. Then came Vienna Agreement. And last but not the least, TRIPS Agreement. It came into 1994, known as the Treatment on Trade-Related Aspects of Intellectual Property Rights. It is administered by WTO, that binds all the WTO members to further rules and obligations for IP laws or IP rights in general and addresses trademark laws. Also implemented harmonization of trademark laws of member countries. For example, here we see its prior user claim. We see if there is a prior user or you are proposed to be used. In the US, the language changes language changes slightly, which is intent to use or in commerce. So the vernacular shifts, but the crux, the concept remains the same. And that's what WTO does. That's what TRIP did after 1994. Now, our domestic laws, as you can see here, Trademark Act, the harbinger of trademark law in India. Most important, trademark rules. They tell you about the procedure, they tell you about the filing. So you need to understand the nuances of trademark rules once, and it is also up for amendment. I think there is a bill on the table. Hopefully we'll get it soon. And one document that I found while I was working, which is a draft manual for trademarks practice and procedure. You will get this after your session. I would request the organizer to provide you with the same. It has been Gita or any secular book for that matter, because it contains the step-by-step guiding process for filing a trademark. Of course, it doesn't contain everything, but it contains the crux so that you can have a fluid mechanism on how to navigate during trademark filing. As you can see, again, WIPO is responsible for administration of Madrid Protocol, you can see. Now we'll move to next slide. Types of trademarks recognized in India. As you can see, there are multiple. This is not an exhaustive list. There is smell mark also. And you'll be glad to know that in India, there was a first smell trademark registration in November 2025, which was done by a Japanese company, Sumitomo Rubber Industries Limited, for a floral fragrance smell reminiscent of roses applied to tires under class 12. So it was a benchmark for us. So these are the types of trademarks recognized in India. Word mark includes just words. Composite mark, both logo and word. Sound mark. There are multiple sound marks also. First sound mark was Yahoo Yodel. If you have heard, if you're not too young, then you might have heard of Yahoo Yodels. And then recently in January 2026, Taj also registered its first sound mark in the hospitality sector, and even Kingfisher registered its iconic jingle as sound mark in February 2026. This is some trivia. giving these examples because I want you to understand that we are moving beyond the traditional marks and we are inculcating significant changes in our trademark system with the help of sound marks and smell marks. Now, we'll go to practical aspects of filing. Now we are getting to the meat of this session. Why trademark filing? We know what is trademark. We know why registration is important. Now we go to why of it. First of all, if a client comes to you with a trademark, of course, they have an affinity towards your brand. They'll tell you to file this particular trademark, but you as a professional, you have a duty to do a clearance search before you file so that you can give a transparent opinion, your knowledgeable opinion to your client that, look, we are trying our best to file, but there are certain limitations because your brand might not be what is good for filing it if it's not distinctive or too descriptive. Sometimes they do not listen because they have certain affinity towards their brand or they have been in use for a couple of years or multiple years for that matter. But this part is very important so that we can assess the risk after filing. For example, if there is objection raised or there is an opposition after advertisement in the journal. So you can see you have to identify the prior marks early so that you can be well accustomed to any challenges that might come further, so that your client and your client's time doesn't get wasted and your time doesn't get wasted. Now, where to search? Where you can search, basically, a quick Google search might not suffice. You have to go to first IP India's public search. They have, last year, they have modified the entire search based on AI and ML search system. And they have also updated that in their TMA form, it is important to do a first prior art search of your brand name, AI ML search, so that you can apply for the trademark. Now you understand why this step is very important. When you go there, they'll give you an exhaustive list of similar looking, similar sounding, phonetically, structurally, conceptually similar trademarks, and you can assess your risk. You can also do a cursory search or MCA or on Google or your preferred browser. Now we'll go to the next slide. Registration, trademark registration in India. We know that after clearance search, we have to file the trademark because the client is very eager to protect his brand. I understand. I am also very eager about trademarks, but we need to understand few sections and few rules before we get into it. First of all, trademark filing, you need to gather some of the information prior filing so that it saves you time. It makes the process more fluid, more lenient on you. And if you start doing it multiple times, it might just be a matter of 5 to 10 minutes. First of all, now after clearance search, we do application filing. The application filing form is TMA. It's a new form which contains certain details that we need to ask from our client, and that needs to be filled diligently on the portal, on the IP India Trademark e-filing portal. Now, the first thing that's required is particulars of applicant, name, address, jurisdiction. Now, why jurisdiction is important? Jurisdiction is important of your brand or per se because it navigates you which registry it will go through. In India, there are 5 registries, 5 IP offices, main IP offices located. It's in Delhi, Ahmedabad, Kolkata, Mumbai, and Chennai. If you go to IP India website, you will know which states come under which jurisdiction. For instance, Madhya Pradesh comes under Mumbai and Jammu Kashmir comes under Delhi. So when you understand your jurisdiction, you will understand which registry your application is going through. Now, second is the type of applicant. Is it an individual, an MSME, startup, NGO, trust, LLP, LLC? It could be anything. But why it matters? It matters because first, the documents that you require during filing. Second, fees, which is very, very important. And I'll share an anecdote with you that how sometimes fees can be a point of contention, even with eager clients as well. Now, after you have specified your type of client, you will go to the portal and specify what kind of client, and you will have to upload documents for that. If you are a LLC, LLP, you need an COI, MOU. And if you are a MSME or startup, you need an MSME or Udyam certificate. And if you're an individual, you just need a POA and I think your ID proof. If it's too much information, you don't have to put it. Sometimes I've seen that some people don't put their Aadhaar or they only put their PAN card. Next is to allocate what kind of trademark you're filing. It is also very important. Class, sorry. Now the class of your particular service or goods that you're providing. That is niche classification, of course. Now, why class is important? Because prior to choosing anything, you have to pick the type of form you're picking, the type of applicant you are, and the third most important thing is class. Before these three, you cannot even proceed to trademark application. As you can see on the slide, the fees is given for individual and MSME, it's 4,500, offline it's 5,000, but nobody does it offline anymore, maybe in some areas. For other classes, you have 9,000 per class, and in offline filing, it's 10,000. Now, other documents that you require is a POA, which is power of attorney. If you're not filing as an individual, if you are filing through an agent or an advocate, POA signed and stamped is required. Now, here also comes a point of contention regarding stamp paper or the amount of stamp paper is required. Ideally, in Delhi, we do the POA on 100 rupees stamp paper, but after dealing with fewer clients, we have seen that multiple registries, not Delhi registry, there is objection over 100 rupees stamp paper also. So this is kind of contingent on the registry, but ideally we follow 100 rupees stamp paper for TMA filing. Now, after you have put in all the details, you have e-signed your particular document, you have paid the prescribed fee, your trademark application number is filed, and your application number is generated within 2 to 3 hours. Not immediately, but within 2 to 3 hours. And your filing date is secured immediately upon submission of the application. And also another, if you have to file under Madrid Convention, you need to file an international application within 6 months from your initial date of filing so that you can secure an international registration number. Now we come to the second part, which is examination. Before that, examination is it's a very sometimes you get objection, sometimes you don't get objection. So it is not like after you have done your due diligence, it happens you get an objection raised. Sometimes we were surprised that yes, there's a descriptive mark, but no objection was raised, even though they were not prior user. So it has been a gamble, but we'll navigate through it. What happens if they're at examination stage? Now, after filing of an application, it gets sent to Vienna codification. If an applied mark consists of figurative elements especially, codification of the figurative elements is done as per Vienna Agreement, and then the application moves for the examination. But if the trademark is applied only for word per se directly, then it directly proceeds towards examination. Now, the TMR is essentially trademarks registry. The trademark registry does application in 2 stages. First, examination report is prepared by an examiner, and then the application and examination report is then forwarded to the examination controller for approval. At this stage, application may be accepted or an objection may be raised as per provisions. In the case it is accepted, it will be published in TM Journal, else examination report will be issued to the applicant containing the specific objections that you need to deal with, and which needs to be replied within 30 days from the receipt of examination report. Now, after your examination report is generated, you will see that certain objection is raised by the examiner, and then you have to deal with, or you have to ascertain those examinations, and you have to rebuttal those particular objections. How do you do that? You do it by filing an examination reply under MISR, miscellaneous reply. Now, the reply, as I have already stated, needs to file within 1 month. If it is found satisfactory, then your application will be then published in TMJ. TMJ is Trademarks Journal. If it's not satisfactory, then it proceeds for show cause hearing. And I'll tell you, sometimes it happens that the hearing, it can be 1 hearing, or it can be at max 4 to 5 hearings also. So you have to convince registrar so that the hearings show cause hearings does not get generated, because the number of hearings exceeds, your trademark application will also be delayed. So we try to deal with objections in MISR only, but we ask for hearing because if there is some uncertainty, we can clarify ourselves in hearing. Sorry. Now, another thing that I personally like to do, and I have seen other people also do that we can also upload some documents which we were not able to. What if we were not able to do it in examination reply? What we do is we file supporting documents for show cause hearing, and sometimes even after that, the examiner finds it satisfactory and no multiple hearings are conducted. So this is a key trade practice that what I have seen people do, and it has been very fruitful lately. We have discussed about show cause hearing. Okay. Now, after you have, like, after the examiner is satisfied with your submissions, your trademark application is then published into the trademark journal. After the publication, within 4 months of publication, the parties, any interested, invested, vested, or a third party has the right to file for an objection within 4 months from the publication. Now, copy of the service is given. Copy of the service of the opposition is given to the applicant, and then the applicant has to file. Opponent has to file the counter statement within 2 months. Now, I will not go into the detail of opposition because it will be handled in your third session of trademark, and they'll do a better job in going through the nuances of opposition. I'll just giving you a cursory information that yes, this needs to be done. Further, after 2 months of counter statement, you have submission of evidence within 2 months under evidence affidavit rule 45, 46, 47. Now, after you have dealt with, if there's no objection, you have successfully able to publish your trademark application in the journal, you have crossed all the hurdles, there is no opposition, then your trademark is registered. If there is an opposition or any multiple oppositions, the entire process gets delayed, because again, opposition is a very exhaustive process. One thing I forgot to deal with is what we can do if there's an objection raised. So the most common objection that I have come across is 91A, 91B, 11, like relative grounds and absolute grounds. And one more is the stamp duty is not appropriate. Very rarely I have seen that there's a documentation error or and there's a filing error or there's an amendment that needs to be done. If there is a statutory objection, for instance, under section 9 or 11, there are certain straightforward defenses that you can utilize in your examination reply. First, I like to do is section 17 principle of totality, that we have to see trademark as a whole. There are multiple cases on this particular point that you'll find which is helpful if you put it in your examination reply. Second is inherent distinctiveness. As we have all learned in our undergrad studies and even in our post-graduation, if you have done it, it's spectrum of distinctiveness. It could be fanciful, arbitrary, suggestive, descriptive, generic, but we need to be fanciful and arbitrary for it to be a successful defense and for that objection. Now, acquired distinctiveness. Acquired distinctiveness becomes one of the hurdle when your brand name is not inherently distinctive. So we have to show their prior use. But now prior use is not defined anywhere. It is a very loose point. So how do you deal with prior use? Sometimes the MSME startups are new in the business and they don't have enough invoices or enough sales to show for it. In that case, what do you need to do? So what I like to do is I like to add all the websites that they have, how they have been active on social media, every point of information that I have on themselves, along with prevalent recent judgments. One recent judgment on acquired distinctiveness, which I find very profound, is Mrs. Ishi Ghosla versus Anil Agrawal. It is 2023 judgment. In this judgment, the court states that a trademark or a brand name has acquired secondary character and has come to be associated with the plaintiff's product if it has a certain degree of familiarity. Certain degree is also again open to interpretation. The court further added, to acquire secondary meaning or distinctive meaning, it is not necessary that product is in the market for number of years. As observed earlier, if a new idea is fascinating and appeals to the consumers, it can become a hit overnight. So you see from how this particular judgment, the jurisprudence of prior use, where we had to show decades and decades worth of notoriety or reputation or goodwill, the jurisprudence shifted towards even the overnight successes, like we go trendy or we go viral. not in our brands. I'm just giving a homogeneous example or similar example, not identical. So that's how the jurisprudence is also changing. And the last defense under objection you can do is honest and concurrent use. It is not very fruitful. It works in very rare cases where there is no malified intention, but sometimes it can be helpful as well. Now, after all the hoops, after all the nuances, after all the objections or oppositions you have dealt with, your trademark is finally registered. But it's not as easy as it looks. Let's go to next slide. Okay. Now, we have already discussed there are certain examples that I have put here. For example, if you have trading in legal services, that's class 45. 35 is business and everything. There are almost 40, not almost, there are 45 classes. So 1 to 34 is for goods and 35 to 45 are for services. You have to pick your appropriate class, because when you see a TMF form, you will see that we have to write a specific goods and services description. Now, what I've seen people do, either they copy paste from the niche classification or they write a diatribe of the services that your client is not even providing, or the goods your client is not even providing. So this is where niche classification itself and the newest edition comes into play, that you have to pick a specific class. You write a specific goods and services description. So first of all, no objection is raised. Second of all, it becomes easier for you in opposition stage. And third of all, you get to decide the extent of your brand protection. So please don't overlook this part while filing your trademark application. Next slide. Now, we'll go into detail the grounds for objection and how to respond. Now, we have all read under Trademarks Act 1999 that there are predominantly two grounds of refusal. One is absolute grounds, and you can see in the slide there are relative grounds under section 11. Relative grounds are a bit easier to deal with, but absolute grounds, as it is in the name, are a bit more tactical means. We have already seen the defenses if there's an objection raised. We have already discussed in detail that how can you defend, but that again, what I have given you the defenses for objection is a very limited list. I like to keep a list of my judgments that I've used or defenses I've priorly used, or I have seen people used in their particular examination reply, so that when it comes, a particular specific objection come, I just have to copy paste and inculcate my particular point in that examination reply. So you need to have certain things like this handy. Another thing, while you start filing your trademark application, you need to prepare a list of what you require from a particular applicant. If it's an individual, kind of the description that I've already told you, what kind of provision particulars you require, or their type, their documents, so that you can tell them and you don't have to ask them again and again. So prepare a list for individual, LLC, LLP, trust, NGO, and your MSME startups, so that your filing becomes easier, your time gets saved, and you can focus on other things. Now, we have dealt with this particular portion in detail, grounds for objection and how to respond. Now we'll go to the next slide. Now, one of the most important part and one of the most frequented questions that clients ask me is, Madam, kitna time lagega? Ideally, it should take, as you can see, 18 to 24 months. But lately, after I think 2020 to 2023, we have been looking at some lacunas. We have been looking some delays that nobody's know of. But it's getting better. We have the registry recently, the CPJD IPM, they issued a notice that till April 2026, the World Intellectual Property Day, they are fast tracking the applications. So we are going in a good direction. There are certain drawbacks, but we are working on it. So now we're talking about timelines, cost, and practical tips. So timeline usually takes 18 to 24 months, including objection. But if there's an opposition is raised, the time gets extended. Filing, you see that the filing cost is given in the slide. Now, one time when I was talking to a client, they have already filed 2 trademark applications. They wanted to file third one, but they have already, because they were an NGO, they already had paid 9,000 rupees for each application. They came to me, they asked my ex-manager that, ma'am, what should we do? Because we as an NGO, we cannot afford 27,000 in just application, because we have to go further also. If there's a hearing, we have to attend. So there are certain concerns in that regard also, because not everybody can afford, if they are in other category, not everybody can afford that amount of fees. So we came with a unique idea to register that particular NGO under a startup, so that they can get the fee rebate under the individual startup MSME filing. And we were successful to do that. So you have to also find unique ideas how to navigate through cost also, because sometimes it can, if you have to file a multi-class application, for instance. So multi-class application is 99. You can file a particular brand name for under multiple classes, but for each classes you have to pay fees individually. So it also gets very heavy. So that's why you have to find unique approaches to deal with real life cases. You know what is written in your statutory or procedural provisions, but when you deal on real life, you get to learn more. You try to do a bit problem solving. Now, the next suggestion you get after trademark filing is that you can use your trademark and you can use TM adjacent to your brand name, which clients find very self-soothing, but they're also very anxious about the timeline. So you deal with the objection and opposition as they come. Now I'll go to the next slide. We all know that the trademark validity is 10 years and it's renewable. You have to give 9,000 rupees fees again, and you have to file the particular form with particular prescribed fee. Now, next slide. This is again very important. Once your trademark is registered, people see it is at the end of the light. Okay, we are done. But that's where the most important, what do you call it, process starts. Now you have successfully registered your trademark. You need protection of that particular trademark, because you are bound by a territory if you're not an MNC. If you're a small time owner, small sole proprietor, small company, small firm, small startup, you don't know how your trademark is getting infringed. But in this case, big companies, they are very vigilant when if they see their trademark getting brutalized. So they take quick resolution, they take quick action. But for each and every one of us, it's not possible. But your awareness as a professional needs to be there, so that we can suggest, we can advise them accordingly. Now, we all know that after trademark is registered, there's another stage, which is filing for an LPC. The registration certificate that gets published is not a legal document. It's just the proof of your registration, but it is not admissible at the evidence stage. So what you do in that case, you ask the trademark registry for a certified copy for a certain prescribed fee. That is known as LPC, or legal proceeding certificate, which happens post-registration, which is the first step post-registration. After you suggest your client, okay, you need to have this, they'll understand that yes, there are again quintessential prerequisites to after trademark registration also. Now you have filed certified copy, which is under section 137, and you can file it in your portal under I think yes, you can file it to your portal, where you can file for certified copy under TM. I think I'll have to check again. It's been some time that I file LPC, but the fees is 900 rupees. Now, second is renewal. Of course, renewal is a long due. It's a 10-year duration, a decade duration, but you can also give your clients reminder. Now, you have to keep it in use, because if you do not keep it in use, the other party, if the opposite party, if they are eyeing for your brand, they can file for cancellation, they can file for rectification, and your brand gets tarnished. And there is also section 33 acquiescence. If you are dormant, if you're not aware of your rights, if you are dormant for 5 years or more, then your brand, you already give up the rights to your particular brand. Now you have to also see, if you are a licensed or a registered user, you have to see how your rights are protected, because there are multiple ways that you can assign or license your rights. You can protect their goodwill, you could do without your goodwill. So there are certain criteria in that regard also. Now, as you can see from the paragraph below, that trademark rectification and cancellation is a very crucial process. Again, it's a post-registration enforcement strategy, so I will not go into depth, but you can read the section and you can understand that, yes, we talk about pre-filing, but post-filing, there are certain things that we have to deal with. Now, enforcement options. I have reiterated it again and again, and I'll say that I am only going cursory about the enforcement options, which is your remedies. We have already discussed passing off in our introduction, which is covered under section 27 clause 2. Now we'll deal with what other remedies you have. Now there are civil remedies also under trademarks law, which includes and not limited to temporary, permanent injunction, damages, cost of litigation, accounts for profit, destruction of inventory, or destruction of inventory. Also, you can even approach High Court for raid, search, and seizure by local commission by way of Anton Pillar injunction, or freezing of their assets, your competitors' assets or products by Minerva injunction. And we have seen that with the influx of e-commerce websites, with the scam that's going on, now we have a new remedy for unknown infringers also, which is John Doe orders for dealing with counterfeit products when the originator of that particular counterfeit product is unknown. You have seen copyright, you have seen John Doe orders in copyright also, when we have to protect personality rights because we don't know who is infringing their rights. And here also you can file for John Doe orders. Now we have criminal remedy also because it's a serious offense, riding on somebody's goodwill, taking their profit, loss of monetary gain. So we take this very seriously. So the criminal remedy is under section 103, which is imprisonment for a period not less than 6 months that may extend up to 3 years, and a fine not less than 50,000 that may extend up to 2 lakh rupees. And there is provision for repeated offenders also. Last but not the least is administrative remedy. Administrative remedy is what we don't talk about much, but it is very interesting once you start practicing IP law. I'm sure my fellow speakers will enlighten you in depth. But yes, it's one of the interesting part of trademark post-registration dealing. So it is opposition to trademark registration or rectification or cancellation of register, and even cross-border measures, which is customs recordal, where you can stop your counterfeiting products from leaving your jurisdiction. Online takedown, we have dealt with John Doe orders. Okay, you can see in detail the remedies. I've also, as a trademark or even an IP lawyer, I have provided the sources. I am not stealing anything. So this is the discretion we need to maintain. We need to be vigilant in each and every way. Now we have, as you can, I'll pause for 2 minutes for this slide. I've already dealt with the contents of this particular portion, but I wanted to know that there are plethora of remedies that you could fall back upon. Now, we'll understand that filing, I have taken the entire process that usually takes up to 2 to 3 years within an hour. I tried to be I tried to be brief, but there are so many things to discuss, so I might have rambled a bit. But the point is, this is not a straightforward process. Clients come with their own set of problems. You have your own set of limitations, and you need to work around. And for that workaround, you have been given very, very important tools. First of all, which is your Trademarks Rules 2017, which is, again, remember, due for amendment. So you need to check on that. And your Trademark Act. You will find most of the things that you have not found in real practice experience. You will find half of the things there. Now, we'll go to the common mistakes that we need to avoid. Filing in too few classes. Sometimes you have a brand, for example, Unilever. Unilever has its reach in multiple spheres. But what happens if they create a product, or if there is an MNC and they want to, navigate into another one of the domain that they want to sell their brands in under their particular brand name, which is already registered. So you cannot be too narrow. So you have to see the extent of your products, your services, and then accordingly you have to file for the classes. One trend, again, I'm also seeing that people are very hesitant in filing multi-class applications because they think that if we are filing for 2 to 3 classes under multi-class application, and if there is an object, God forbid, if there's an objection or opposition raised, we are going to stuck, all 3 of our classes are going to stuck, and we have to have loss of profit. So what I've seen clients request or even insist on doing is filing multiple classes in multiple trademark applications. I understand the reasoning, but multi-class application is there for the reason for us to use. But multi-class application is there for a purpose, and filing multiple classes or too few classes will just defeat the purpose of trademark law. Again, now second is adopting a descriptive mark. We all know you cannot be too lackadaisical with your brand name. You have to be very unique because the competition is raising the competition as it peak. Even you have gotten some epiphany of some idea, you will find that there is some sort of reminiscent in other brand also. There is no limit to what you will do or what brand name people pick. Now, third is delaying after use begins. Sometimes I have seen also applicant, they have been functioning for 4 or 5 years, but they don't want to go through extra stage, which is user affidavit. One thing that I forgot to mention in filing, that if you are a prior user, you need additional document, which is a user affidavit, which needs to be signed and stamped, where you have to show the first use of your brand name along with an evidence to support that particular date. Now, clients, for the sake of convenience, for their sake of convenience, if they have almost descriptive or not too distinctive mark, they ask कि नहीं madam, आप जो है अभी propose to be used में कर दीजिए, बाद में देख लेंगे. In that case, what happens that I have to deal with objection, and while I'm dealing with objection in examination reply, I have said, oh, they are been here for 4 to 5 years. They have been working under their brand name. They have been selling their goods under their brand name. What happens? The registrar will ask me, then why have you filed proposed to be used? Why have you not filed prior user affidavit? So these are the things that you need to be very transparent to your filing to your client, that yes, these particular small instances have a long-term effect on your filing process and time duration. Missing statutory deadlines. Now, this is one of the most important part where most of the applications in objection stage or opposition stage gets abandoned, because it's the provision that if you are not replying within time duration, if you're not giving appearing within time duration, then your trademark is supposedly abandoned. So statutory deadlines need to be followed. You have to know on your fingertips is that when you have to file ER, when you have to deal with opposition notice, when you can file counter statement, or when you can file EA under 45, 46, or 47. Third is ignoring the opposition stage. Again, not missing deadlines is important, but you cannot let go of that stage because there are multiple opposition that you have to deal with, and it is a very 6 months is a minimum process, but it can go as far as up to 1 year or 2 years to deal with particular opposition. Sorry. So these are the things that you have to keep in mind before and after filing of trademark. That would be all. I have something else for people. Just a second. Okay. So I'm going to again reshare my screen if I'm allowed.
Yes, ma'am.
Sure, thank you. Just a second. Okay. So I cannot show you one of the applications I have filed because I am bound by confidentiality, but I have picked out a random application. Again, one of the tricks, I'd like to give you this particular trick that somebody was doing, and I inculcated in my professional life as well. Yeah, is that they used to type 7-digit random numbers in trademark IP search, and then they used to go through the form, because when you see the trademark status, if you go to that particular portal, you will type in the application number, any application number, you go the captcha, and you can see every uploaded document, the correspondence, the trademark application, and everything. So for the sake of confidentiality, I have picked out a random filed trademark application. As you can see the fees, you can see the applicant name, and here address for service is if you are filing from an agent. This is where all your communication from filing to objection, opposition, even post registration, every communication will be done at this particular address and that particular email. But why it is important for a particular email address or particular address of service? Because when you are served with an opposition notice, you have to jot down the receipt of delivery, because from that day your particular deadline starts from submitting a reply. So these particular small points are very important so that it should be homogeneous in your filing through and through. So that for multiple applications, you don't have multiple address for services or mobile number or email. Email and address is more important than your mobile number. Now you can see applicants' agents, their logo. It's a device mark. Now description, they have kept description in brevity. So it gives you chance to oppose also, deal with objection also, and not deal with hasty opposition when they are published. It's a proposed to be used. Now it's digitally signed and your trademark application has been filed. Now another thing is, this is your objection notice from the registry. This is the official objection notice for the same trademark application that we just saw. So here, as you can see, these are the common 92A or 91A, 91B are the most common objection that you will get raised, and you know how to deal. Once you start dealing with it, you will get a hang that how to proceed with dealing with such objections. As you can see, they give you timeline, they give you the process. It's very intuitive. The trademark filing portal, the entire process is very intuitive. You just have to practice. You just have to read each and every word and get assimilated. Here, if the objection is being raised under 11.1, you will see all the what do you call it, your deceptively similar or confusingly similar marks over here in a line. And this list could be up to, it could be 3, it could be 16. I have seen an application with 30 similar marks. So the sky is limit. Now, last but not the least is this notice. As you can see, that when you are not timely, then also a reminder is sent to you. Why? You can ask either for hearing, you can ask either for reply to the examination report, and you have to deal with it promptly. As you can see, they have already stated that liability, that it will be abandoned. So it is you as an applicant to be very vigilant, to be open-eyed, to be open ears, so that your client does not suffer in long term. As you can see, everything is very intuitive. You see how they make everything so much easier for you. So yes, that's it. And thank you for listening to me. Thank you for having me. I hope I was anyway helpful to you people. And thank you for being here. Back to you, and Gitanjali.